these laws were used to make sure that the Africans are not able to move freely or exercise certain rights?
Thank you for the question. I believe when thinking about the question of strict legal text interpretation and fair outcomes, especially when it comes to petty offenses that have a colonial relic, I then believe that in looking at those kind of issues, a judge must have at the back of his mind the fact that these are colonial laws that might not be truly applicable in the current circumstance, and therefore those laws must not be strictly applied. Because the reason why the masters wanted the laws was to restrict, for example, the subjects.
So how would you then not apply them strictly? So somebody has, I know it's not a matter that will be before you, because most of them are in the Chief Magistrate Courts. For example, the offense of drunk and disorderly.
I believe in looking at that question is to look at the kind of punishments that you can mete out with respect to those offenses. For example, you can say, I'm giving you a suspended sentence, for example, so that you do not unduly punish these citizens of ours who would have taken a little bit much more than they ought to have. Okay,
and if it's a repeat offender?
If it's a repeat offender,
the same context of drunk and disorderly?
If it's a repeat offender, then you would then apply the law properly.
Okay. Can you order that a person seek treatment, because you know alcoholism is a disease?
Yes, you could, yes.
Okay, thank you.
Yes.
Thank you, Chair.
Yes, I'm Jokindumu. I was a bit late, so let me introduce myself. I see that you have written a very interesting article on the presidential powers for clemency, and you've talked about how the victims of such crimes are not given the opportunity to say what they think. So taking your studies in this area and applying it in a different context, under Article 168, the Judicial Service Commission can recommend the removal of a judge, and the procedure is that it then goes to tribunal, and if the tribunal then states or it says that the judge should be recommended, the judge should be removed, that judge can come to the court or to the Supreme Court on appeal. The Supreme Court has original jurisdiction. This process from the beginning had a complainant who went to the JSC, was gone to the tribunal, but at the Supreme Court appears to have no locus. What would you say in terms of the rights of the complainant at that appellate stage?
Thank you for the question. I truly believe that a complainant should have a say, at the very least, at the Supreme Court, because this complainant took part in this whole process from the beginning up till the tribunal. So I still believe that complainant ought to be given an opportunity to say something at the very least.
How would the complainant approach the Supreme Court? In what capacity?
Perhaps as an interested party.
Okay, thank you very much.
Yeah. Thank you, Chair. Yes, good morning once again.
Good morning.
In your introductory remarks, you mentioned that you work at the Tax Appeals Tribunal?
Yes.
Yes, I have not seen any reports from DISPOP concerning your tribunal. Do you file your daily returns?
Yes, we do. Yes.
You were not given any reports from DISPOP in preparation for this interview?
I was given, yes.
You were given?
Yes.
Okay, for some reason I have not been given a copy, but I'll find out after this. I thought you were not given. So you also work at Kabarak University.
I used to.
Do you have any reports from there concerning your performance? I believe they must have a performance appraisal system.
They do.
Yes.
I left working in June of last year.
Oh, okay.
Yes, when I joined the tribunal.
Mm-hmm.
Yes.
And maybe your last appraisal from there, now that I don't have any from the tribunal?
The interesting bit is that students also appraise you. So you can imagine that students would be very keen, especially when the results are out, to mark you properly. Mm-hmm. But I want to report that my students were extremely very happy with my performance in terms of class attendance, in terms of quality supervision, in terms of engaging with them, in terms of mentoring, and much more. So they were extremely very happy about that. I must also say that the administration was happy with the kind of work that I have done, especially with the students, because these are our children, and they require much more than just teaching them. So the school is extremely very happy, was extremely very happy about that.
So your appraisal system is an oral expression of either happiness or
it's a 360. It's a 360.
I get the 360, but yes. I'm just wondering whether there is a report maybe to support what you're telling us.
There is a report.
Yes.
Yes.
But you didn't supply us?
No, I did not, unfortunately.
Okay. Yes. Hopefully you can.
Yes, I will.
Even after this.
Yes.
So the question I have for you is about the different modes of ADR, specifically mediation. What is mediation in your understanding? How does it take place?
So my understanding of mediation is where two parties come together with the help of a third party who helps them resolve the dispute. So the mediator does not actively take part in this dispute. The mediator just encourages the parties to reach a settlement. So the eventual bit there would be that they would reach a settlement, and then there would be mediation settlement,
okay.
which would be the mediation agreement. Yes.
Okay, the settlement agreement.
Yes.
Yes. Now, in the context of court annex mediation, at the end of it all, of course, the settlement agreement is adopted by the court. But is that agreement final, or is there room to challenge it? And if there is, what are the grounds on which you would challenge a mediation settlement agreement?
I believe that the mediation agreement can be challenged on the basis, for example, if one of the parties say that I did not understand what I was signing on to, for example. Secondly, that in reaching this settlement, for example, I was not aware of what was really going on, and also if the agreement, for example, it would be manifestly illegal, so it could be challenged on that basis as well.
Okay, when it's illegal,
yes.
Any other?
Yeah, that is what I can.
Okay.
Yes.
Okay, thank you, and I wish you well.
Thank you very much.
Thank you, my lady.
Thank you, Honorable Chair, and welcome again, Wakili.
Thank you.
Now, the Constitution of Kenya assumes the theme of good leadership and integrity throughout its chapters. Could you tell us, or name to us, the legal framework that governs leadership and integrity?
So thank you, Commissioner. I believe that the Constitution would be the first rubric when it comes to leadership and integrity, and the other legislations, for example, the Leadership and Integrity Act, the Public Officer Ethics Act, the Ethics and Anti-Corruption Act. There is also the Conflict of Interest Act that would speak to that.
Okay, thank you. Now, could you also name to us some of the Bangalore principles of judicial conduct and explain to us how you will apply them?
So, thank you, Commissioner. Some of the Bangalore principles of judicial conduct would be impartiality. That is one. So I believe that a judge ought to be impartial in the way they conduct the matters in court, so that the members of public could then have faith in the judicial system. Without impartiality, members of public would not have faith in the judicial system. The second one is integrity, in the sense that if a judicial officer is not a person of integrity, then the court will lack the authority then to assert itself, because the members of public, for example, would be viewing it to be a court that can be swayed and that is not that cannot be trusted. Thirdly is independence. I believe that a judge ought to be independent so that they can then make their decisions in an independent manner, without external influence or even internal influence. That way then it is then assured that this judge would decide on cases based on the law only, as opposed to external factors. Lastly, I believe that competence is also important, so that this judge is then able to execute their duties in a manner that demonstrates that they understand the law, and therefore then ensure that the public would be confident in the decision that this judge reaches. So I believe that those are some of the principles of Bangalore principles, yes.
Okay. Thank you. I wish you all the best.
Thank you.
Thank you, Honorable CJ. Counsel, could you please tell us your understanding of emotional intelligence and how you will apply it in your role as a judge?
So thank you. My view is that there is a distinction between intelligence quotient and emotional intelligence. So that emotional intelligence would be how it is that you deal with people, the soft skills that you would then have, and how it is that you're then able to relate with others, especially in a workplace. So one of the key themes around emotional intelligence would be empathy, that you're able to empathize with the situation of the people that you're working with on the basis that you have understood them, and therefore then you're going to take into account how they feel about that particular issue. So that then is important. The second one is self-awareness, that you must also be aware of yourself as an individual, about how it is that you act around people, what it is that you do not like, so that you're also able to introspect and to be able to adjust to the circumstance, especially in the workplace. So yeah, so those are some of the issues around emotional intelligence, yes.
Okay. Please tell this panel your experience in the area of mentorship and any role that you've taken.
So thank you very much. So mentorship is important because you then grow the next generation of leaders, for example, or you then help a junior colleague who is just joining to learn the ropes, so that their entry into the workforce then becomes a little bit easier and a little bit softer. So I have mentored many young colleagues, but more so what I'm proud of is the mentorship of the students at Kabarak University, because this is the future of this legal practice, for example. So I've mentored in excess of 300 students in different areas, be it academics, be it outside academics. Yes, so I have mentored.
So what role do you play as a mentor? What is your role?
My role is hand-holding, in terms of holding their hands, and also depending on exactly what it is that this young mentee would want to know.
Okay.
So I would tailor-make my mentorship to them depending on what it is that they exactly require. Okay. So that it's just a general mentorship to just say that we're mentoring all of you. So it's specific to the mentee, yes.
Okay, right. Now, my last question, I'm looking at your profile and some of the feedback we got after doing our background checks. There is quite a bit of good comments that have come from the public, but maybe there's something that I do not see here. What would they say they don't like about you?
I don't know what they would say, but I would guess that during my stint at the County Assembly of Kericho, I was extremely very strict because it was necessary to be strict. So perhaps at that point in time, the members of the County Assembly weren't extremely very happy about me. But I know that we ran a very good county at the County Assembly of Kericho and ensured that, for example, the County Assembly of Kericho, for the very first time, was given an unqualified audit report by the Office of the Auditor General, just demonstrating the fact that we put in place good systems at that county. But I guess feedback has changed now, that they would be saying that I was the best speaker.
Did they try to impeach you?
There was no attempt at impeachment.
Okay.
Yes, thank
you. All right,
you.
thank you. I wish you well.
Asante.
Good morning again.
Good morning.
Fine. Now, how can technology be used to improve access to justice?
Thank you very much, Commissioner, for the question. I think the understanding is that funds are not unlimited, and therefore then our solace would be to run through technology so that we can leverage on technology to ensure that most of our Kenyans access justice. So I believe that technology is the future in terms of access to justice. In terms of ensuring that cases are filed seamlessly and that hearings are conducted virtually, that then cuts down on the cost of accessing justice.
Do you think that there is place for use and application of artificial intelligence?
Out here, they say that the fifth disruptor would be AI. So I believe that there is place for AI, but not generative AI, so that, for example, the judiciary judges would not be using AI to write judgments, but would use AI, for example, for processes that do not require generation of new information. So that, yes, so I believe that that would be important, but also ethical use of AI. Yes.
What is the role of the judiciary in socioeconomic development?
So thank you for that question, Commissioner. I believe that looking at the stage, for example, I see the place of judiciary being ensuring that there is social justice. Our constitution in very many places speaks about social justice and the welfare of the vulnerable. And I then believe that judiciary will then play a great role. It is playing a great role, but I think it plays a great role in social justice, and therefore then it speaks to the society in general and what the judiciary can then do. Thank you.
Thank you, and wish you well.
Asante.
Yes, Council, we are almost coming to an end. You said you have only 4 pending cases.
Yes, I do.
At the Tax Appeals Tribunal.
Yes, I do.
How about the overall tribunal? What is the backlog like?
So for example, last year we handled 704 cases, 704 cases. 443 of those cases, there were consents in 443 of those. 240 were handled by the various panels. 21 cases moved on to this year because they were pending judgments. So the judgments were then delivered in the month of January of this year. So we then pick up again this year.
Okay,
Yes.
so in other words, you are real time at the Tax Appeals Tribunal. You hear matters as they are filed.
Yes, yes. Just safe to say that there is a 120-day period that parties are then given to attempt a mediation.
Okay.
Yes.
Is mediation working?
Yes, it is, yes.
The
Because
one assisted by the High Court or the one?
the one assisted by Kerry.
By the KRI itself?
Yes, yes, the respondent,
Okay.
yes.
How about the one assisted by the High Court? Is it working?
I haven't seen much from that front, but from the cases that we have handled, just like I was indicating before, that, for example, 441 cases were handled internally. So the cases were filed at the Tax Appeals Tribunal, but consents were filed in 443 of the cases.
So the tribunal itself is also facilitating
Yes, yes.
mediation?
So because when parties come, then we'll give them the opportunity to then attempt mediation.
Very well.
Thank you.
There is an answer you gave to the question asked by, I think, Commissioner Omwansa, followed up by the AG, about the court suspending the invalidity of a statute. And you said once the court has declared a statute invalid, the court cannot suspend that. And I wanted to ask you, supposing the court suspended the Sexual Offences Act, what would happen to the offenders who are being processed in court, the ones to be charged of the offense? What would happen? Wouldn't that cause mayhem?
Perhaps I wasn't very clear. I'm sorry about that, Madam Chief Justice. For such a scenario, like the one that you have mentioned, is that those offenders would need to be processed. There shouldn't be chaos in the country. So then perhaps I wasn't extremely very clear. So in that instance, then it can be suspended.
Yes, because there is an assumption of
Yes.
the constitutionality of a statute.
That is true. That is
Right?
true. That is true.
So that is why a structural interdict is given to allow the amendment if the registrar deems it fit.
That is
because that law is supposed to cater for a lacuna
That is
or a
true.
situation.
That is true.
Now, once you suspend, what happens?
There'd be chaos.
That's what I wanted to clarify.
I'm sorry if I wasn't very clear.
Yes, thank you.
Asante.
So I think this brings us to the end of this interaction with you, Council, this morning. But before we release the candidate, we always allow them also an opportunity to engage us. So the floor is yours.
So I would just wish to thank this panel for having me here today to have this conversation about the position of the Office of the High Court Judge. I'm truly grateful to this panel, and I'm also truly grateful to the judiciary for the role that they have given me at the Tax Appeals Tribunal. I'm eternally grateful. And I would want to just commend the judiciary that it is doing a very great job, and I think the future is only brighter. Thank you.
Thank you very
Asante.
much. On behalf of the commissioners, we wish you success. We wish you well. We will get in touch with you when we complete the exercise. But we like to encourage every candidate who appears before us that they are Kenyans. We appreciate them and the work that they are doing, serving Kenyans in whatever capacity you are serving them. And keep up doing the good work that you are doing.
Asante.
Yes, so you are released. You can
Asante,
take your
asante.
writing pad and your water.
to empathize with the situation of the people that you're working with on the basis that you have understood them, and therefore then you're going to take into account how they feel about that particular issue. So that then is important. The second one is self-awareness, that you must also be aware of yourself as an individual about how it is that you act around people, what it is that you do not like, so that you're also able to introspect and to be able to adjust to the circumstance, especially in the workplace. So yeah, so those are some of the issues around emotional intelligence. Yes.
Okay, please tell this panel your experience in the area of mentorship and any role that you've taken.
So thank you very much. So mentorship is important because you then grow the next generation of leaders, for example, or you then help a junior colleague who is just joining to learn the ropes, so that their entry into the workforce then becomes a little bit easier and a little bit softer. So I have mentored many young colleagues, but more so what I'm proud of is the mentorship of the students at Kabarak University, because this is the future of this legal practice, for example. So I've mentored in excess of 300 students in different areas, be it academics, be it outside academics. Yes, so I have mentored.
So what role do you play as a mentor? What is your role?
My role is hand-holding, in terms of holding their hands, and also depending on exactly what it is that this young mentee would want to know. Okay. So I would tailor-make my mentorship to them depending on what it is that they exactly require. Okay. So that it's just a general mentorship to just say that we are mentoring all of you. So it's specific to the mentee. Yes.
Okay, right. Now my last question, I'm looking at your profile and some of the feedback we got after doing our background checks. There is quite a bit of good comments that have come from the public, but maybe there's something that I do not see here. What would they say they don't like about you?
I don't know what they would say, but I would guess that during my stint at the County Assembly of Kericho, I was extremely very strict because it was necessary to be strict. So perhaps at that point in time, the members of the County Assembly weren't extremely very happy about me. But I know that we ran a very good county at the County Assembly of Kericho, and ensured that, for example, the County Assembly of Kericho, for the very first time, was given an unqualified audit report by the Office of the Auditor General, just demonstrating the fact that we put in place good systems at that county. But I guess feedback has changed now, that they would be saying that I was the best speaker.
Did they try to impeach you?
There was no attempt at impeachment.
Okay.
Yes, thank you.
All right, thank you. I wish you well.
Asante.
Yes, good morning again.
Good morning.
Fine. Now, how can technology be used to improve access to justice?
Thank you very much, Commissioner, for the question. I think the understanding is that funds are not unlimited, and therefore then our solace would be to run through technology, so that we can leverage on technology to ensure that most of our Kenyans access justice. So I believe that technology is the future in terms of access to justice, in terms of ensuring that cases are filed seamlessly, and that hearings are conducted virtually. That then cuts down on...
Morning, Dorcas Oduor, Senior Counsel and Attorney General.
Bringing in your achievements, your experience, your skills, and your innovations. Just a glimpse of what we got from the public participation is that we should recommend men and women who are hardworking, heavy lifters, men and women of impeccable integrity, and men and women of high moral probity. So within 5 minutes, if you can tell us whether you have all those values, how you have them, and how you're going to bring them to the High Courts.
Thank you, Honorable Chief Justice. My name is Dominic Rono. I began my legal career as a legal practitioner, and I worked for a period of 4 years as an associate advocate, practicing in the area of criminal and civil litigation. During that period, I gained invaluable experience in actual courtroom work. So I then believe that that experience that I gained would be critical and important in the office of a High Court judge. Thereafter, I worked at the Kenya National Commission on Human Rights for a period of over 10 years. At the Commission for Human Rights, I worked particularly in ensuring that Kenya meets its international obligation with respect to human rights conventions and treaties that it had ratified. Chief Justice, I believe that the work that I did at the Commission would be important when it comes to the question of the High Court, the office of the High Court judge, in a sense that I understand human rights fully, and I believe that that then gave me a good competence, and I know that that would be a key attribute of a good judge. Thereafter, Honorable Chief Justice, I moved to the County Assembly of Kericho, where I worked as a county speaker for a period of 5 years. I believe that there I was able to oversee legislation at the County Assembly for the whole period of 5 years. That, in my own estimation, would be a good experience in a sense that I was able to interact with people, especially members of the County Assembly, and also ensuring that the county ran well without a lot of disputes. I believe that the fact that I was able to interact with many stakeholders would be a key attribute to bring to the office of the High Court judge, because justice is not only rendered by the judges, but also in collaboration with stakeholders. So I believe that that would be a critical element to bring to the judiciary. Thereafter, Chief Justice, I moved to Kabarak University, where I taught law. I taught in the public law department, and I taught fundamental rights and freedoms. I was also able to mentor students. I was able to supervise students with respect to various dissertations touching on human rights. And I believe that experience is important in the sense that it deepened my understanding of research and my ability to do research. So then therefore, I believe that that is a skill that I could bring to the High Court with respect to conducting proper research. Subsequently, Chief Justice, last year I was appointed as a member of the Tax Appeals Tribunal, where I have been working up till now. I have been able to learn a few things about hearing cases, writing judgments, writing rulings, and also working with colleagues, because we work as a collegiate. We sit in a panel. So I have been able to learn how to work with people. I have been able to learn how to write judgments. And more importantly, we have been able to do good work with respect to our case clearance. So I believe that that demonstrates that I would be a heavy lifter, because as I speak to you this morning, my panel only has 4 cases pending. So that is, I think that demonstrates that we have done extremely well, and that that is something that I could bring to the judiciary. I thank you.
Thank you very much. I notice you have 3 masters.
Yes, Chief Justice.
Master of Public Administration, Master in Sexual and Reproductive Rights in Africa, and Master of laws with merit.
Yes.
You have a patent for masters, not a PhD.
I'm actually, thank you, Chief Justice. I'm actually undertaking my PhD. I am somewhere in there,
Okay.
hanging in there.
Now, on the sexual and reproductive rights in Africa,
Yes, please.
do you think
An head of station. I carried my work in Karsen competently, and I worked very hard there, but my career was unfortunately cut short when I was shot by Al-Shabaab militants together with my court staff, and also including the prosecutor, on our way back from Kipini Mobile Court. Thereafter, I was transferred to Milimani Commercial Court, a very busy court, and I worked hard in Milimani Commercial Court, and I delivered numerous rulings and judgment as the statistics would show. In Milimani, I also managed or coordinated the Mahakama Popote initiative, a very innovative initiative which is IT-based, where magistrates in other courts are able to share their workload in Milimani virtually. And the Chief Justice, recognizing my administrative skills and also my legal competency, appointed me to a committee to draft the Mahakama Popote rules, which rules we drafted and they were due for publishing when I left Milimani. Subsequently, I was also transferred to another very busy court, Makadara Law Courts. And my performance in Makadara Law Courts speaks for itself. 200%, 203. Out of my expected performance of 9%, I performed 18%. Chief Justice, I've heard you severally in this interview saying you are looking for a tractor. I believe I'm the tractor. I can lift, as shown by my record and my statistics. What does the High Court need? High Court needs hardworking people, men of integrity, impeccable integrity, which I am, and good character, honest, humble. I am humble. I handle litigants and advocates and accused persons before my court with dignity. And even those who come to my court will have admitted severally that I have handled them and they feel at ease with me. However, I am very firm. I'm independent and impartial in my decisions. I do not use my good cases to compromise any of my decisions. When I ascend to the High Court, if the Commission finds it fit to give me the job, I will do 4 things. Number 1, employing my registry skills, I will do a thorough case audit of the cases allocated to me, because one thing which I realized when I was in Milimani commissioners and Honorable Chief Justice is that as much as there is this backlog, there are so many cases which are spent within the system. So I will do a thorough case audit, and while engaging the stakeholders, I will ensure those cases which are dormant and which are spent are removed from the system. I will also, being a mediator, I am very passionate also about ADR. I will employ ADR in dispensing justice quickly. I will also root for substantive justice and avoid these many interlocutory applications. And I will deliver extempore judgments, rather no rulings, sorry for that, for applications which are easy and they can be dispensed without delaying the hearing. Finally, I am a very straightforward person. I am not corrupt. I can say that without fear of any contradiction. And I will be a crusader of anti-corruption, against corruption when I go to the High Court. Every court I go, the first day I always declare to everyone I meet and to anyone who cares to hear that I do not entertain corruption. And that's the same thing I'll do when I go to the High Court. Thank you very much.
Thank you, Chief Justice. Your Honor, what is your understanding about a derivative action, and what conditions should be met before a court can grant leave for a person to proceed on the basis of a derivative action?
Derivative action, that one, I do not know that one.
Okay.
Yeah.
Okay. Now, then, if a matter goes through trial,
yes,
you know, before a high court or even before a magistrate's court,
yes,
and the magistrate listens to the matter, both the evidence of the plaintiff and the defendant, and then delivers a judgment, and thereafter, at the point whereby the parties are executing a decree or the decree from the judgment, the defendant discovers that there was fraud, that the judgment was procured by fraud. What would be the cause of action for that defendant, and how would they go around it?
Okay, in the case of Lorian, which was a case in Nyeri,
yes,
the court determined that a judgment in a land matter, that a judgment which is obtained by fraud should not stand. But once the judgment has been delivered,
yes,
there's nothing much the defendant can do. What he can only do is to file another cause of action to impugn that judgment.
Yes, then you cannot say that there's nothing they cannot do.
Yes, as in, yes. At the point of when the judgment has been delivered, in that particular judgment,
yes,
he cannot, there's nothing much he can do. He will have to file another suit.
So he will file a suit and
yes,
ask for what?
He will now ask that that judgment be declared a judgment which cannot stand and which is inoperative on the basis that it was procured by way of fraud.
And that will be through evidence? So
yes,
it will be a suit?
Yes, it will be a suit, a different suit.
Okay.
Yeah.
Thank you, you are correct. Asante.
Thank you very much, Honorable Commissioner.
Thank you, Honorable Chair. Honorable Rotich, in criminal law, what constitutes a life sentence? A man who is 70 years old is sentenced to life imprisonment. A 23-year-old child, boy or girl, is sentenced to life imprisonment. What is that life imprisonment?
Life imprisonment, my lady, is not necessarily life in the sense that he is sentenced for another life imprisonment which is put at another 20 years or so. Basically, that man, even if he is released from prison, there's nothing much left of his life. So it does not necessarily mean life in the sense of he has to die while in prison.
So how long is a life imprisonment?
If I'm right, Honorable Judge, 50 years should be life. 50.
So 23-year-old, 70-year-old are both going to serve 50 years?
No, the one who is younger obviously will serve longer, given the age, and then the one who is older will serve a shorter
So
Period.
is it unfair then, or is it discriminatory to have the one who is 23 years have a life imprisonment of 50 years and the one who is 70 years not serve a sentence of 50 years?
I do not think it is discriminatory. It is about the practicality in it. Because if you sentence somebody who is 70 years to serve 50 years, it does not, it's not practical. So it's all about the practicality of that sentence.
Are you aware of any decisions emanating from our courts that have spoken to this issue?
I'm not aware of the particular decision, but I'm aware that issue of what meant constitutes life sentence has been litigated upon, and a decision has been made. I cannot remember on the top of my mind at the moment.
Do you know what decision was made?
That life sentence does not constitute the natural life in the sense of somebody has to serve in prison until they die. A certain number of years, which practically, for all intents and purposes, that person will, the other life which will be left, more or less, will not be productive.
Do you also know whether the Supreme Court has had an occasion to look at this issue and has given guidelines or a guideline as regards what needs to happen?
As I have stated, I am not familiar, rather I need to check on the particular authority and maybe the guidelines.
Yes, please read the authority of Julius Kisau Manyeso, where the Supreme Court corrected the Court of Appeal when it attempted to reduce that sentence to 40 years. And the Supreme Court, in my view, rightly said it is not the business of the court, but it is the business of Parliament to effect the necessary amendments, if at all. Now, so much as regards the technical question. I also wish to bring to your attention, Honorable Rotich, that there is a complaint that we received in respect of your candidature, and we made you aware of that complaint.
Yes.
And this was a complaint by one Edwin Washira on behalf of Dewdrop Enterprises Limited, and he says that he had a matter before your court and you found against him, and that in your response you actually admit, yes, that there was that matter, but this was an issue whereby this complainant was not satisfied with the outcome of your ruling, and he has since filed an appeal. Is that correct?
That's correct, my lady.
We've had an opportunity to look at it, and it is also our view that you're right in saying that he was challenging the merits or demerits of your ruling, and hence we have put this matter to rest.
Thank you, my lady.
Thank you
so much.
Honorable Chief Justice.
Thank you.
Thank you, Honorable Chief Justice, and Honorable Rotich. I must commend you for your zeal to serve the public. You are full of energy, and I think you'll do us good if you are successful to join the High Court.
Thank you very much, my lord.
Just one thing.
Thank you.
What is your understanding of the concept of separation of powers?
Concept of? Come again. Sorry.
The concept of separation of powers. How do you understand the concept of separation of powers?
The concept of separation of powers is that the three arms of government should discharge their respective mandates. The judiciary should be allowed to do its work.
What is its work?
To dispense justice and also to interpret the Constitution. On the other hand, the government also should be allowed to do its executive, to discharge its executive mandate of running the day-to-day affairs of the government, of the executive. And on the other hand, Parliament should do its work of making laws. However, this separation is not entirely practical. Apart from that, whereas that separation exists, the three arms of government also work together on areas which are common to them to serve the citizens of the country. So it is there. I mean, all the three arms of government should respect their different mandates, and none of the other should interfere with the other in the discharge of their duty. Everyone should perform their functions. So that's basically what I understand about in respect to the concept of separation of powers.
Okay, so
yes.
Taking you back to the discussion you had with Judge Commissioner,
yes.
Parliament passes a law that says if you're guilty of offense A, the sentence is death or is life imprisonment. Judiciary comes up and says, despite that law, in upholding human rights and going through the international instruments and all this, the sentence of life, that this life imprisonment, shall mean a certain term. This is judiciary, not parliament. Would you consider that as an overreach by judiciary into legislature?
I would not.
You will not?
I would not, because once the judiciary has discharged its mandate and rendered itself in the best understanding and application of the principles, including international law principles, then the judiciary has done its work. So it's up to Parliament to make a decision on what to do about what the judiciary has stated or has declared.
Okay, so do you think there are any instances where the judiciary can overreach into their arms?
Where judiciary can overreach is where judiciary now.
Sorry, it's off. I don't know what has
Sorry, judiciary goes into the realm of making decisions. Making decisions, and which in effect would be like performing executive function. The judiciary, I believe, they should be free to render their position, their legal position, to the best understanding, applying all the principles. But then, what judiciary should not do is to make executive decisions or direct executive decisions.
Okay, thank you. I wish you the very best, Honorable.
Thank you.
Good morning.
Good morning, Honorable AG.
Now, the Constitution of Kenya provides that the High Court has unlimited jurisdiction in criminal and civil matters.
Yes.
This jurisdiction sometimes is comprised within a term referred to as inherent jurisdiction. What do you understand by the term inherent jurisdiction?
Inherent jurisdiction is that jurisdiction which is in the court, even if there are no particular legal provisions to make the court operate. It is what constitutes the court in terms of its functions and its being. So even if there was no, the law does not cover all issues and all whatever everything that happens in court. So inherent jurisdiction is that jurisdiction which is in the court to do that which is lawful and to do that which will facilitate the dispensation of justice as a court.
Now, further to that,
Yes.
it also has residual powers.
Yes.
What do you understand by that?
Residual powers, I think, would mean that when everything else has been done, all else has been done, and then there's something, there's some directions which need to be given, and the court has residual powers to make directions on what should be done.
Now, section, I think 18 or 17, section 18 of the Civil Procedure Act,
Yes.
provides guidelines on when and how a high court can transfer a matter from one court to the other. What powers has the High Court to transfer a matter from one court to another?
Honorable Attorney General, do you mean the High Court transferring a matter from one High Court to another High Court?
I'm putting it to you. What you make of it is your call.
All right. Thank you, Honorable Attorney General, for that.
Are you familiar with Section 18 of the Civil Procedure Act?
Yes.
When can a High Court transfer a matter from one court to the other?
When, for instance, in respect to where a matter is an ELC matter, and the court finds that this is not a High Court matter, I believe the High Court has jurisdiction to transfer the matter to the relevant court. And also the High Court can transfer a matter from one High Court to another High Court, and also from one court to another. The lower courts have no powers to transfer a matter from one magistrate court.
My question was
Yes.
High Court.
Yes, yes.
When can a High Court transfer a matter from one court to another court, and which courts? Pursuant to Section 18 of the Civil Procedure Act.
Where a matter, for instance, is filed in let's say Machakos, and the matter, another High Court, I mean, the matter relates to an issue which the cause of action arose in Nairobi, geographically. So the High Court has jurisdiction to transfer a matter to be heard in a court which has jurisdiction geographically to handle the matter.
Okay, let's help ourselves out of this.
Yes.
Section 18 of the Civil Procedure Act provides that a High Court can transfer a matter to a subordinate court. Where do you get the provisions where a High Court can transfer a matter to another High Court?
The High Court Administration Act.
Section?
Well, I cannot point out the right section at the moment, but there is this practice where a party would file a matter which entirely relates to a matter which happened in Nairobi. So administratively, the High Court can order that matter, so that to avoid the issue of forum shopping, could be transferred to a court within the location where that matter ought to be heard.
Can the High Court use or invoke inherent jurisdiction to confer jurisdiction to another court other than the High Court?
Yes, the High Court, as you have rightly pointed out, Honorable AG, as jurisdiction to transfer matters to lower courts which have jurisdiction?
No, that one is provided for under the Civil Procedure Act.
Yes.
That a High Court can transfer a matter to a subordinate court.
Yes.
My question is,
Yes.
can the High Court use inherent powers or jurisdiction
Yes.
to transfer a matter from one High Court to another?
Yes. Yes, it can.
Are there provisions in our law allowing the High Court or giving power to the High Court to transfer a matter from one High Court to another, or a court of equal jurisdiction to the High Court?
As you have rightly pointed out, Honorable Attorney General, the inherent of the jurisdiction of the court to facilitate dispensation of justice and proper administration of justice can transfer a court which is which ought to hear the matter and where the matter arises for convenience and that to facilitate.
Okay, let's finish this. Let's agree first.
Yes.
We are understanding each other.
Yes.
Is there a law that allows the High Court to transfer a matter from one High Court to another? Having agreed that there is a law under the Civil Procedure Act giving power to the High Court to transfer a matter from the High Court to a subordinate court, is there a provision of law that gives power to the High Court to transfer a matter from one High Court to another High Court or a court of equal jurisdictional status?
Well, I cannot cite the law immediately, but I agree with you, Honorable Attorney General, that then the court may then, exercising its inherent jurisdiction, transfer a matter to another High Court. But I'm aware that the High Court Administration Act makes provisions that a matter should be heard where the cause of action arose geographically.
Okay, recently the High Court has pronounced itself over the validity of using inherent powers to transfer a matter from the High Court to a court of equal jurisdiction, in which case it was referring to Environment Court, Land and Environment Court, and the Labor Court. Do you remember any authority on that?
I do not remember any authority, but I'm aware that where a matter has been filed in the High Court.
No, I just asked you for the authority.
No, I'm
so
not.
After this, I think you can show me the legal provision, the one you are referring to, where a High Court can transfer a matter under the law to another High Court.
I'll check that.
Thank you.
Thank you very much.
Thank you, Chair. Good morning once again, Your Honor.
Good morning, Honorable Commissioner.
You need some water, or we?
Yeah, let me take some. Thank you. We can proceed.
You did submit to us decisions you have done in civil, commercial, and criminal matters. They demonstrate strong command of procedural and substantive law across the areas I've just cited. They are well structured. You're able to clearly identify issues, and you sequence your analysis carefully. The decisions, as I've read, they emphasize due process, structured legal reasoning, judicial restraint, and you avoid speculative conclusions of overreach. The tone throughout is calm, impartial, and professionally restrained. So I commend you for that. My question is, since the promulgation of the current constitution, the scope of judicial review in Kenya has evolved, particularly with enactment of a law and jurisprudence from the Court of Appeal. Are you aware of those changes? If yes, kindly explain.
I'm aware of the changes. Previously, before 2010, judicial review was anchored in the Civil Procedure Act and Law Reform Act. But with the promulgation of the new constitution, now judicial review has constitutional underpinnings in Article 47 of the Constitution and it provides that right to fair administrative action should be expedient, should be efficient, lawful, and procedurally fair. In the new constitutional dispensation, judicial review is now more robust, and because of the new ingredients which are captured both in the Constitution and the Fair Administrative Actions Act, now the courts have found that actually, apart from looking at the procedure, judicial review has now extended to looking into the merits of a particular administrative decision. The grounds for judicial review have also been expanded. Initially, they were just, the judicial review was founded on whether a matter was ultra vires, whether a decision was ultra vires, whether the parties were given a fair hearing, whether there was natural justice. But now, judicial review in its expanded and enhanced position, now there are new grounds like legitimate expectation and proportionality, which have been and reasonableness, which have now come into play because of the new constitution and because of the act. So it has been expanded. They are merit-based. It's merit-based, and apart from just issuing the traditional orders of certiorari, mandamus, and prohibition, now even the courts through judicial review can issue structural interdicts to direct the government to carry out some actions which they ought, which are lawful and which make citizens to enjoy some rights to implement within some certain period of time. So it is more robust, more enhanced, and it can also apply now. Judicial review now even applies to private entities performing government functions. So it's enhanced and more robust.
Okay, I'm okay with that, and I wish you the very best.
Thank you, Honorable Commissioner.
Yes, the Supreme Court has laid out a 9-point test to assess whether public participation has taken place or not. What are the 9 points?
Okay. Public participation should be real, should not be cosmetic. The parties should be given a notice. The public participation should be such that parties, rather the citizens, are able to influence the decision. They should be given notice of where the meetings will be done. But the Supreme Court has also found that public participation does not have to be only oral. It can also be by way of written submissions. It can be done by by way of written submissions. I don't know how many have I.
Okay, those are
okay.
enough.
And I will quote the case of the BPI case.
Okay.
And the British American tobacco case.
Okay.
Yes.
So assuming Parliament has, the National Assembly
Yes.
has a bill before it,
Yes.
and it calls for public participation, and people give their views, is that the end of public participation for that bill?
I didn't get it again.
The National Assembly,
Yes.
it has a bill before it.
A bill, yes.
They then call for public views from the public on the bill. The bill is going through certain stages. Is that notice inviting public views, is it sufficient
I do not think it's sufficient. There are other levels of public participation which can still be called.
When? At what point?
Once I believe once the Parliament has debated the bill.
Yes.
I don't know, I'm not very quite sure, but at some point, I don't know, before the third reading or something, they also went at the committee stage.
Yes.
The committee also can call for public participation now
So this notice I'm saying,
yes,
that goes out to the public is at the committee stage.
Yes.
Does Parliament have to do any further public participation after that?
After issuing the first notice,
after the committee receives views from the public, does Parliament need to do any more public participation on that bill?
No, I do not think.
Okay, thank you very much.
Thank you very much.
What if Parliament amends, the bill has been presented to the people for public participation, and then in the second and third reading they make substantive amendments to what was presented to the public?
If Parliament introduces new amendments and what was not there before at the initial stage of the bill,
yes,
then it will require public participation, because it will mean that now these are new laws which have come up, new substantive amendment which have come up. So I think the public are entitled to be heard.
But does Parliament have a latitude to make those amendments based even on the views from the public?
Based on the views of the public?
Yes.
Yes.
And then if they made that amendment, would there be a need for them to go back to the public?
If they make the amendments based on the views of the public, then there would be no need to go back.
Okay.
But now if they introduce their own amendments, which there has been no public participation, then I think it will be like introducing new things, which I think it will not fit into the test of public participation.
All right, thank you.
Thank you, Chair. Good morning once again, Mheshimiwa.
Good morning, Honorable Commissioner.
I just want to have a brief engagement with you concerning your performance from the report I have from DISPOP. I don't know if you were given a copy.
Yes, I was given a copy and I looked at it.
Is it accurate?
Yes, it is.
It is accurate, okay. Yeah, as you said earlier in your introductory remarks, indeed you are carrying more than your expected weight at the rate of 202%. What is expected of you is 9%, you're carrying 18%, that is commendable. I commend you for that. I also note that your backlog situation at Makadara is not so bad. I've done the math. You have only 12% of your cases are backlog. So about 88% of your cases are current. I think that is also good. Your court productivity is also quite good at 696 against the national average of 370. But where there is concern is your case clearance rate, which is lower than the national average by far. You are at 80%, the national average is at 104%. I don't know what the challenge could be, and also maybe you can share with us what you are doing at Makadara to enhance the case clearance rate.
Makadara is a very basic court, Honorable Commissioner, and there is a very high volume of cases. Mm-hmm. You finish a set of cases this week, another set, which if it's not more, comes next. So it's because of the petty cases. Mm-hmm. One of the biggest problems I've seen in Makadara is the infrastructure. That court is very small to serve the population it serves. Like Milimani, where I worked, the number of magistrates are, I understand they are now about 27. Whereas Makadara, which serves the whole of Eastlands and does so many criminal cases, only has 10 magistrates. But I understand the challenge, because it's a challenge of infrastructure. So once we have more magistrates, we will be able to achieve that case clearance rate and even surpass the national average. As you've seen, we are working, but then our numbers cannot allow us to achieve a high case clearance, because cases keep coming, new cases every time. There is a very high turnover of new cases being filed on day-to-day basis.
Incidentally, I also worked in Makadara, and I agree with you. A lot of cases, I think you serve about 40 police stations.
Yes, 42 actually.
42 police stations.
Yes.
And as you say, a lot of them are petty cases. And I appreciate that the numbers are low, and I know for us to get to, it will be a long time coming before we have optimal numbers on deck. But as at now, what are you doing, especially now that you mentioned that a good number of your cases are petty cases? What are the interventions you're putting in place to make sure that there's a high turnover of these cases as well? As they come in, you're able to clear them faster and dispose of them.
The interventions we are putting in place, let me just say this before I come to the interventions. Most of these petty cases, invariably, most of them plead guilty. So you are able to dispense with them. What can we do ourselves? We just,
for instance, okay, let's say 50% of them, or maybe 60% of them, petty cases have pleaded guilty. What even 60s? Let's say even 70% have pleaded guilty.
Janos, because it's my cup of tea. And I thought I would go back to school to get a certificate of what I thought I already knew. But I'm glad that even beyond that, I learned many more new things. It's the beauty of learning. One of my lecturers is here, Daktari. I then went to the University of Nairobi, enrolled for Masters of waiting for the graduation. I decided to enroll for a short course at the London School of Economics, which I have finished, and I'm very glad about that. And I'm doing these things because, not because I want a pay increment in terms of salary. You know, ours is fixed. It doesn't matter how many PhDs you do. But it's because I interacted a lot when I was serving in my previous station with a lot of government officials, and I realized the kind of weight of the faith with senior government officials, and I could go home thinking that this is not we are not doing the In Keharo, I am very glad that we have been able to hold our In fact, yesterday I was came here. We were trying to see how they can do the kind of projects we are doing in Kiharu. And I realized that the entire relative to the income, and we mean that the incomes are going higher relative to the standard of life that we need to keep up with. For the economy to grow, when we talk about the economy, is usually us. There is no drawer in an office called government called the economy. There is no drawer utaambiwa fungua hiyo drawer ndio ya economy. Funga sasa tuende hii ingine hakuna. The economy is us here, our parents in our various villages, our aunties in our various estates, our uncles in their various places of work, and our mothers in our various offices. That is what the economy is. When we add what we are all doing called output, it is what gets measured, and then we say the GDP grew or the GDP did not grow, it grew faster or didn't grow faster. And therefore, when we talk about incorporating all of us, men, women, the young, the not very young, across all demographics, we are actually talking about the growth of our economy. Because economy also measures productivity. Productivity is, we are 100 people who their total output is what becomes the GDP. So the more I produce, and the more the other persons produce, the total sum, which is the economy, then increases. What I want to mean is this. When we were growing up, and the generations behind our, that came before our parents, some of the demographics, majority of us in this hall, would be dependents. There is a language I want to avoid totally in this seminar, so I know you mutavuta ili mshike what I'm trying to say. We would be at home, doing what? Doing work at hapo nyumbani, kuangalia boma. So what that means is that we throw in the productivity over half of the population to below what is recorded by the government figures. How wise would that be to any economy? That's why sometimes I sympathize with these economists who try to oppress women. I sympathize with them, even futuristically. Because you are cutting off half of the population not to be productive. What that means is that the productivity of the other half, then, when you look for average, it will be half of itself. Because if half increases by 100, but the other half does not increase by anything, the average then is 0 to the half of this other one. So the productivity for everyone on average goes down. And therefore, the issue we talk about equality, equity, giving opportunities to everyone, including our sisters, our mothers, it should not be an issue we are discussing in conferences. It should never. Because it is the most reasonable, logical thing to do. That you give a lady the opportunity to do what they can do best. Because as they advance their productivity, the productivity of the entire economy then progresses. So equality, equity, opportunities for all, starting from education, that is not an issue that people should discuss. It is an issue that we should all implement, and especially at the macro sense. I'll highlight a few points because the chair told me, tukikuja Mombasa, let's not talk too much difficult jargons. And because you had other speakers, that's what the chair told me. These people are waiting to hear from you about investments. So the other points, I thought they are important, but I'll go direct to what you are looking for. Because we had very distinguished speakers who would highlight the other areas better than myself. But allow me a few minutes to highlight some few things that I thought are important, because here we have people serving in the public sector, we have people serving in the private sector, we have people with or running their own businesses. And there are things that cut across, which I also learn when I'm speaking about them. And it's about leadership, it's about impact, and it's about sustainable growth. Not about the country, about ourselves, our organizations, our businesses. So don't look at it purely about, you work for the Central Bank of Kenya, so you just zero into the Central Bank of Kenya. You look at it expansively. The first thing is that many times we confuse that leadership is just being elected. That you've been elected as an MCA, as an MP, all the way to the highest position. But leadership happens across. Even where you are not in mid-level management, you are also a leader. So we must carry that obligation without necessarily passing over to the next boss. Let the responsibility rest where you are so that you provide solutions to the level where you are. Political leaders, business leaders, social impact leaders, whatever we do, because we cannot all fit in the bank to become CEOs of the bank, we can't all fit in to become politicians. Wherever we are serving, you may actually end up having higher impact where you are serving more than I could have as a politician. The second thing I have come to appreciate about leading with integrity. And because like all of you here, we all have ambitions of becoming very wealthy and rich. I can tell by the faces that I am seeing, you all want to be rich and wealthy. And even if in a home, financially independent. We all want that. Yes, I am, you are somebody's wife, mother, but there's nothing wrong with being financially independent. Even supporting him when he needs a boost. Unfortunately, there is no much response. So, I have come to appreciate that I have never studied the wealthiest people in Africa or the wealthiest in Germany or France or the world where I have seen a swindler being featured. I have never seen somebody being featured in the Forbes list. And the designation is that they stole money using a pen. I have never seen one. I have also never seen one person being celebrated, receiving any prize, be it Nobel or any otherwise. And the designation there is that he was too intelligent in stealing. And therefore it means, in whatever we are doing, money is not the head of it. If money is not the head of it, it means you can get more of it by not looking at it as the head. But it is also important to get money where you can sleep at night and you don't have bad dreams. And I can say that loudly. You'd rather have in fact, the money you look with your own heart and brain, somehow it comes with its own fertilizer. Unaweka pahali, matunda ni mingi. Hii ingine kwanza, the harm, the mental torture of trying to hide from what you did last week, the energy you put into that would be enough to make you double the money. So leading with integrity. And I'm not here as a moralist. I'm here as a pragmatist. The third thing is, as we lead, including Keharo, all of us here, whatever leadership role we are having, because majority of us are already having those leadership roles. Collaboration. When you are a leader and you want to grow and you can't collaborate, it means you're already grounding yourself. Because whatever I do as member of parliament for Keharo, when I come here and hold the mic and I talk about Keharo Masomo Bora, practically think, am I in Keharo today? Am I supplying rice or unga ya ngano? ya kupika chapati. It means there is a lot of collaboration with teams, with the principals, with officers in my office, that is the staff, with the people involved. When we talk about projects we implement through labor-based, it is not me who go there to supervise. It is the collaboration. But what gets reported, the chair will hold the mic when you invite NYORO in a function, and he will say he's been rated as the best performing MP. Just think about that. Think about that with the position you hold. A best performing MP. Where are all these other people then? Because I've never held a shovel to build a classroom. But she holds the mic and says, tupigie makofi mheshimiwa. Amefanya kazi ya kiharo masomo bora. Fine. I'm not the implementer. What am I trying to say here? As a leader, if you don't have the capacity to collaborate, it is important from today you teach yourself through polishing your personality to be a leader who collaborates. Because collaboration does not only help the team members, it actually helps you as the leader. Because what you'll get reported at the end is what the team did, and you are the representative of the team. Collaboration means you also feel the other people, you also provide solutions, you show the way, but you also listen so that you can continue making the system better, the system of the area that you serve and work. There is a course specifically I am pursuing on navigating through challenges and opportunities. It's one of the courses I'll be undertaking at Harvard. That course, there is something I want to investigate beyond what you all know. Because there is something I've seen. We remember Margaret Thatcher. We remember Angela Merkel. We remember all these ladies, Wangari Maathai, and the others. In functions, we show their photos for inspiration. A photo will be put here for inspiration of a lady who did so well, of a man who did so well, Winston Churchill and the rest. But there is usually no footnote or another slide showing the kind of challenges they went through. So when you are leading and when you are progressing, it will be naive for us to think that you'll get a straight line, which you can see from here the head. That's not how things are framed. We must know that the people we read and they inspire us, we only usually see the one side, ile wamejipaka mafuta na makeup. We don't see the other side where they even never had time to comb their hair, they never had time to apply even Vaseline on their face. That area we don't see. When we talk about Margaret Thatcher, no one of us here would raise their hand and say she was bad. But do you know in the 1981, Margaret Thatcher approval rating was 19%. It means she was so down, no one in Britain wanted to see her. But you are here with your small challenge in your office. This is the one that just hit you fast, and you're almost giving up. My friend, you can't afford to do that. Because there is no history book anywhere that remembers people who did so well without conquering challenges. So when challenges come, they should make us stronger. In our various areas, huyu bosi wangu mtu bure, sasa hata ukifanya hii hasikii. That's a good challenge to handle. The other challenge, and the other, and the other. I'm avoiding to go to specifics because we are very diverse here in terms of where we work. You are an MP, and then a small challenge hits you, you can't think. The people we read and admire, part of the reason we admire them is conquering challenges, whatever diversity is. The other thing is mentorship. Mentorship is both backward and forward. Backward mentorship is the one you become a mentee. And I can tell you, some of these things, we started hearing them from nursery school. Mentorship, integrity, nini, all those things are, every time you come to a seminar, you can always start taking notes of the things that will be spoken there. And before you attend, you already have the notes. It's because of their importance, and it's also because I think somehow it is known we hear but we don't do. So we need to keep on reminding ourselves. There is a story I always give. When I left campus, not when I left, when I was in first year, I started working for a stockbroking company of our former MP called Genya Karaoke. Ilikuwa inaitwa Genya Karaoke and Company Stockbrokers. In my first year, long vacation. A stockbroking company of our former MP Genya Karaoke. Just listen to this again. A stockbroking company in my first year in campus of our former MP Genya Karaoke. I'm repeating because that's the point I want you to get. I was first year, I started working in a stockbroking company owned by a person who was MP for Keharu. I am here. Most of what I do, economically speaking, is in the capital markets, meaning stockbroking and the rest, and investments, and I'm MP for Keharu. Do you think that is a coincidence? That is not a coincidence. That him, who is Genya Karaoke, used to be a youth winger of our other former MP called Kenneth Matiba. That our current governor, Iroko Kangata, and myself were youth wingers of Genya Karaoke when he died in Keharu in 2007. That Iroko Kangata became MP for Keharu, and that NYORO is the current MP for Keharu. And that all those people are not related by blood. Even if I say nothing else about mentorship. Mentorship is not about, oh my, nikitaka kuwa kama Olive Mogenda. Nikitaka kuwa kama governor this or that, governor Achani. Mimi nikitaka nikuwe kama family